interfere and take forcible possession of the institutional property on 15/5/2019. On coming to know about the illegal acts of the defendants, the plaintiff and her husband, being seen, immediately approached police and orally informed about the defendant's interference over the institutional property. At that time, the police personnel called upon the defendants and advised not to indulge in the illegal high-handed acts with respect to us. This was the reason I approached the court, my lord.
Yes.
Even at the revenue.
Yes.
ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್? ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಕೇಳಿಸ್ತಿದೆ, ನಮಗ್ ಕೇಳಿಸ್ತಿದೆ, ಬೇರೆ ಕೇಸ್.
Yes, sir. Yes, sir.
Usually, my name is sir. Sri Umesh Molimani?
Yes, yes. Sorry, my lord, some technique. Under these circumstances, I approached the Honorable Court, my lord, with for seeking the assistance legal aid. But the trial court, in its order, my lord, there are 12, my lord. Page number 42, my lord. No doubt the court can draw presumption under section 133 of Karnataka Land Revenue Act regarding the entries in RTC, but it is rebuttable presumption. And considering the facts, this court finds it difficult to draw such presumption. My lord, my name is showing in the revenue records. And even the documents which the defendants are relying, they are in possession regarding the regularization of the pump set electricity, my lord.
Yes.
These are all prima facie goes to show that I am in possession.
Yes.
And the agreement to sell is not disclosing the possession, my lord. Even
Yes.
For a while, it is considered that I have suppressed the factum of sale transaction. That doesn't mean that the defendant should become the owners of the property, my lord. Possession, they have to legally, possession should be shown, my lord. I have shown and proved prima facie my possession. Revenue records have not been believed, my lord. Therefore, even the trial court also, the first appellate court also committed the same error, my lord, in its
Yes.
judgment. Thus, to protect my possession, my lord, intervention of this honorable court is very necessary, my lord.
That's all.
Yes, yes.
The petitioner being agreed by the order on IA number 2, dated 23rd July 2021, found in OS number 212 of 2019 by the Principal Civil Judge, JMFC, Bhadravati, and also order dated order passed in MA number 18 of 2021, dated 14 January 2022 by the Principal Senior Civil Judge, JMFC, Bhadravati, has filed this petition. Brief and pleading rights to filing of this petition are as in the respondent, the petitioner filed a suit.
My lord, I sought for the interim order, my lord.
No, sir, final order.
No, my lord, at least I get
Already
notice.
heard the matter.
Notice, my lord. Let them
Illa,
appear. No, my lord. Kindly, my lord.
The petitioner filed a suit in OS number 212 of 2019 for the relief of permanent injunction in respect of 3 acres of land in survey number 26/1 of Kallapur village of Bhadravati Taluk. Full stop. in the said suit, the respondent appear in the said suit. The petitioner has also filed an IA number 2, seeking an order of temporary injunction restraining the respondent from interfering with the peaceful possession and enjoyment of the suitable property. First of the petitioner in support of an application has filed an dispute contending that the petitioner is the owner of the suitable property and for the respondents are the distant relatives of the petitioner, powerful persons in the locality. The respondents are having an evil eye over the suitable property and are repeatedly trying to grab the same by one or the other means. First, the respondent used to pressurize the petitioner to sell the suitable property. First, of the petitioner entered into an agreement of sale with the respondent and not delivered the possession of the suitable property. It is further contended that the petitioner is in peaceful possession and enjoyment of the suitable property. Most of the respondents, on the strength of the agreement of sale, are trying to interfere into the peaceful possession and enjoyment of the suitable property. Hence, the petitioner has filed an application seeking an order of temporary injunction. Most of the said application was opposed by the respondent by filing the objections. First of in the said objection, the respondents have denied the evidence made in the plaint as well as in the application filed with the petitioner. First of it is contended that the respondents, the suitable property was granted in favor of the petitioner by government on 12/1/1972 and on 27/2/2008. The petitioner has entered into an agreement of sale with the respondent number 1 and 4, agreeing to sell the suit property for consideration of rupees 2,50,000 and received amount of rupees 25,000 towards an earnest money and executed an agreement of sale. Executed a registered
Not registered, Miller. It's
executed
not
an
registered, Miller.
agreement of sale and agreed to execute a registered sale deed after preparing the relevant documents. First of it is further contended that possession of the suitable property was handed over to the respondent and the respondents are cultivating the suitable property. It is further contended that the respondents made an arrangement for digging a borewell and also invested a huge amount for cultivation. First of it is further contended that respondents are in peaceful possession and enjoyment of the suitable property. Hence, question of interference by the respondent in the alleged possession of the petitioner does not arise. Hence, on this ground, paid to reject the application. First of the trial court, after framing and the trial court after hearing the arguments on both sides, rejected the application filed with the petitioner by order dated 23rd July 2021. First of the petitioner being agreed by the order on IA number 2 passed by the trial court, deferred appeal in MA number 18 of 2021. First of the appellate court after hearing the parties dismissed the appeal filed by the petitioner, hence this writ petition. Or the learned counsel for the petitioner. Learned counsel for the petitioner submits that admittedly the petitioner is the owner of the suitable property and petitioner is in possession of the suitable property. It is also submitted that though the petitioner has executed an agreement of sale in favor of respondent number 1 and 4, but petitioner has not delivered the possession of the suitable property. He further submits that name of the petitioner is continued in a RTC. Hence, there is a presumption under section 133 of Karnataka Land Revenue Act. He further submitted the trial court has committed an error in rejecting the application filed with the petitioner. Hence, on this, it pays to allow the writ petition. heard and peruse the reports and consider the submissions of the learned counsel.
One more submission. They have not filed any suit for specific performance till today, 2008 till today.
If I submit that the respondent number 1 and 4 have not filed a suit for specific performance of contract. Heard and peruse the reports and consider the submission of learned counsel for the petitioner. It is not in dispute that the petitioner is the owner of the suit scheduled property. It is also not in dispute that the petitioner has executed an agreement of sale in favor of respondent number 1 and 4. Further, the respondents produce the documents to show that the respondents are in possession of the suit scheduled property. And further, the respondents have also that the dug a borel in the social property. Further, the respondent have produced one issued by letter dated 31/5/2011 bears the signature of the petitioner. On the perusal of the same, it reveals that the assistant executive engineer MESCOM authorized the petitioner to legalize the pump set installed in the property of the petitioner. Further, when the petitioner has executed an agreement of sale in favor of respondent number 1 and 4, during the subsistence of the said agreement, the petitioner has entered into an agreement of during the pendency of this suit, the petitioner has entered into an agreement of sale with 1 K. Chandrappa for consideration of rupees 10 lakhs and received 9 lakhs as an advance. And further, the petitioner has received a 90% of the sale consideration amount from K. Chandrappa. First of the petitioner has suppressed the said aspect. And further, the trial court has recorded a finding that the petitioner is not in possession of the property. And further, the trial court has recorded the conduct of the petitioner in executing an agreement of sale in favor of Chandrappa during the pendency of K. Chandrappa. During pendency of suit, it is also well-established proposition of law that temporary injunction is purely an equitable relief, and it will be granted to the person who approaches to the court with clean hand. First, from the perusal of the records, the petitioner has not approached the court with a clean hand. The courts below have concurrently recorded a finding that the petitioner is not in possession of the suit scheduled property, and consequently rejected the application for grant of temporary injunction by the trial court, and same was confirmed by the appellate court. I do not find any grounds to interfere with the impugned order. The impugned order passed with the trial court is just and proper, does not call for any interference by this court under the supervisory powers of Article 227. Accordingly, petition is dismissed.
Sri Rahul Shettigar.
Sorry, suit 2020 the courts are not functioning. Hold on. Okay, dismiss it. There is a judgment of the division bench. I have to follow it. Yeah, suit is filed in the year 2020. Courts are not functioning, and you are seeking for a mandamus to direct the trial court to dispose of the suit. File an application. When mandamus will be issued? If this type of repetitions are being started entertaining, then trial court cannot dispose of old matters. When the suit was filed? When suit was filed? 2020. Go and file application for framing the issues. Not to hearing for some time, learned counsel for the petitioner seeks permission to withdraw the writ petition with the liberty to pursue the matter before the trial court. Submit memo, filed a memo. Memo is placed on record. The petition is dismissed as withdrawn with the aforesaid liberty. That amounts to granting an amendment with the aforesaid liberty. The aforesaid liberty and ಏನು? What is meant by liberty? During pendency of suit. Purchase during pendency of suit. Correct, you have purchased the property during pendency of suit. There is a question of making you as a party. So you filed an application for pleading. Filed an application in the suit. If you notice to respond. Suit is decreed. Respondent filed execution petition. You have purchased during pendency of suit. There is a question of making you as a party. Read section 52 of Transfer of Property Act. Any decree passed against your vendor that binds on you. What about the decree passed in favor of the respondent? Whether this has got a weightage or whether the decree passed to the civil court has got a weightage. Yes.
Number 9 to be and 12 to be say maybe issue against the 12 and 9 million. The saying of the number 12 million.
Yes, you argue the matter will dispose it of. You argue the matter will dispose it of. If you notice to respond.
Number 8.
I appear for petitioner.
Yes, sir.
I appear for petition.
Yes.
But the petitioner is survey number 18/1 to the extent of 27 guntas. Connection A, page 17, Panchayat Parikat and mutation. The respondents are the brothers of respondents are the brothers of the pardon.
What is the impugned order?
Lords, impugned order is emergent notice was issued on my application. Now, Lords, after the order was passed, my lords, my colleague in the court, my lords, she will place the memo along with certain photographs. My lords, all I'm requesting is, my lords, if
Place all
the,
those photographs before the trial court.
my lords, what I'm requesting is, my lords, annexure F, my lords, there are multiple complaints filed, and my lords, I am not saying that, my lords, they have a right to interfere. Even I cannot interfere because we are claim under common ancestor. Annexure B, my lords, annexure A for
Go and
amendment,
pursue the matter before the trial court.
my lords,
Trial court has issued a notice for that also if you file a writ petition.
my lords, my grievance is limited, my lords. My lords, if the
Yes, sir. Court has passed a detailed order holding that the petitioner has not made out a prima facie case for grant of an ex parte interim order of a temporary injunction.
my lords, my request is this. Your lordship may kindly consider, my lords.
You should notice to respond.
Number 10, CH-16.
It's appearing for the petitions counsel in this matter, my lords. It's a very piquant situation, my lords. An advocate of a standing from 1984 states that there was a mistaken recording of the deposition. But the learned judge says that there is no such mistake. So I don't know how to address arguments, my lords. It is rather difficult for me to address arguments in such matters. But ultimately,
better to take out a notice for respond number 2 and 3.
my lords, kindly take page 65. What is that which was requested? Because now the request is not for rectification of those mistakes.
Correct. After recording the evidence, deposition will be handed over to the party to go through the contents.
Lords, that is when. Lords, that is when. Your
The
lords,
presumption. There is a presumption.
Kindly take page 61 for a minute, my lords. Kindly take page 61 for a minute.
Yes.
I fully understand, my lords. I completely bow down to what your lords have suggested. Therefore, I made a submission in the beginning that I am in a very piquant situation to argue this matter. Lords, kindly take page 61 for a moment.
We accept notice for respond number 2, who appears for Davangere Urban Development Authority.
Lords, the contesting respondent is entered caveat. Lords, he is the only person who opposed.
What about 2 and 3?
2 and 3, my lords, will not be contesting parties for the present application. Because it was
file a memo for dispensation.
I will file a memo for dispensation.
Learned senior counsel appearing for the learned senior counsels. We DR Ravi Shankar appearing for Sarvana for petitioner. Submit that notice to respond number 2 and 3. Maybe dispense. Submission is placed on record. Notice to respond number 2 and 3 is dispensed with at the risk of the petitioner. Let the petition be listed in the first week of March.
May just make this request, my lords. Till then, let there be no precipitation before the trial court. May just read one sentence in page 61, my lords, a statement of the
Yes,
counsel.
sir, I have read it.
Just one sentence.
Yes, you read it. Read it.
I submit that. At the time of recording evidence of PW1 in OS number so. I submit that after recording the evidence of PW1, we have gone through the court hall depositions before signing the deposition of PW1. At that time, it was found in the deposition that in the last third line, it was typed as so and so. They point out the error. But both these questions, PW1 was answered as Nijavalla and not as Nija. But in the deposition, it was mentioned as Nija. Since me and my colleague were present at the time of recording the evidence, PW1 brought to the notice of the Honorable Court with regard to the mistakes kept in the deposition before signing the deposition. The defendant had not consented for the correction of the deposition. The Honorable Court was pleased to direct us to re-examine PW1 on the said points in the next date of hearing. Now, this is what transpired in the court.
Virtually it amounts to making an allegation against the judge
now,
who has recorded the evidence.
These are all human errors. I will not say that it's an error. These are all human errors. May request that your lordships may consider that let there be no precipitation before the trial court till the next date of hearing. I will not take any adjournments at your lordships' hands, Even today, I am ready to go on with the matter. The respondent is
Yes,
with
you
your
are
lordships.
with the matter. Then we'll dispose it off.
Please,
Yes.
Page 58 is the deposition which was recorded.
Yes.
What is the second unnumbered paragraph? There is a reference, with reference to the measurements. This is only a dispute is only with reference to measurement of the property. There is nothing more than that. ನಾನು ವೃತ್ತಿಯಲ್ಲಿ ಅಭ್ಯಂತರರು ಎಂದರೆ ನಿಜ. ಸೆಕೆಂಡ್ ಪಾರ. 1 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ ಎಷ್ಟು ಚದರ ಅಡಿ ಆಗುತ್ತದೆ ಎಂದರೆ ನಿಜ. 1889 ಚದರ ಅಡಿ 1 ಗುಂಟೆ ಎಂದರೆ ನಿಜ. 8 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನು 1080 ಚದರ ಅಡಿ ಗುಣಿಸಿದಾಗ ಒಟ್ಟಾರೆ 8712 ಚದರ ಅಡಿ ಆಗುತ್ತದೆ ಎಂದರೆ ನಿಜ. ನಾನು ಮುರಳೀಧರ್ ಅವರ ಆಸ್ತಿಯನ್ನು ಖರೀದಿ ಮಾಡಿದ್ದೇನೆ ಹೇಳುವಂತಹ ಆಸ್ತಿ 9900 ಚದರ ಅಡಿ ಇರುತ್ತದೆ ಎಂದರೆ ನಿಜ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಹೇಳುವುದೇನೆಂದರೆ ಸಿಟಿ ಸರ್ವೇಯರ್ ಪ್ರಕಾರ 10,700 ಚದರ ಅಡಿ ಇರುತ್ತದೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ನಿಶಾನೆ P49 ಅಳತೆಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ನಾವುಗಳ ನಮ್ಮ ಖರೀದಿ ಪತ್ರದಲ್ಲಿ 1182 ಚದರ ಅಡಿಯನ್ನು ಆಸ್ತಿಯನ್ನು ತೋರಿಸಿದ್ದೇವೆ ಎಂದರೆ ನಿಜ. This is where it is stated that it is ನಿಜವಲ್ಲ. This is what was said. ಖರೀದಿ ಪೂರ್ವದಲ್ಲಿ, this is with reference to your document. Exhibit P49 does not refer to this. I will be in a position to demonstrate exhibit P49. Exhibit 49 ಅಳತೆಗೆ ವ್ಯತಿರಿಕ್ತವಾಗಿ ನಾವುಗಳ ನಮ್ಮ ಖರೀದಿ ಪತ್ರದಲ್ಲಿ 1182 ಚದರ ಅಡಿ ಆಸ್ತಿಯನ್ನು ತೋರಿಸಿಕೊಂಡಿದ್ದೇವೆ ಅಂದ್ರೆ ನಿಜವಲ್ಲ ಆಗಿರ್ಬೇಕು. ದೆನ್ ಖರೀದಿ ಪೂರ್ವದಲ್ಲಿ 1182 ಚದರ ಅಡಿ ಹೆಚ್ಚುವರಿ ಆಸ್ತಿ ಅಲ್ಲಿ ಲಭ್ಯ ಇತ್ತು ಅಂತ ತೋರಿಸಲು ನಾನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನಿಶಾನೆ P49 ರಿಂದ 60 ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳುತ್ತಾರೆ. This is, I just wanted your lordships to.
Yes.
But the last sentence, he says that this 1182 square feet existence is reflected in terms of exhibit P49 to P60. ನಿಶಾನೆ P49 ರಿಂದ 60 ದಾಖಲೆಗಳ ಹೆಚ್ಚುವರಿಯಾಗಿ 1182 ಚದರ ಅಡಿ ಆಸ್ತಿ ಲಭ್ಯ ಆಯ್ತು ಅಂತ ಯಾವ ದಾಖಲೆಗಳಿಲ್ಲಿಯೂ ಉಲ್ಲೇಖ ಇಲ್ಲ ಅಂದ್ರೆ this is again they said that this was nijavalla. I am not saying, now I am not saying anything with reference to deposition. I don't want to say that there is something because it will be, as I said, there is a sanctity to the court proceedings, which I will definitely not say anything about the sanctity of the court proceedings as recorded. But kindly see what is the prayer sought for at page 65. Page 65.
Allegations made in the.
I'll withdraw. I'll withdraw all the allegations. Your lordships may. Your lordships may say this, that not in the official courts, I will not be in a position to say this. They have said something, I wanted to take your lordships to what is the prayer sought for, in this, in the.
And moreover, senior advocate did not file an affidavit.
Senior advocate is one who has filed the affidavit, Page 61 is the page 61,
Yes.
He has put in almost about 48 years of practice, in the state, in the city of Davangere. He is one of the leading lawyers, in Davangere. Page 61, your lordships may kindly take. Kindly take page 61,
Yes, I have read it.
He is the senior advocate, who appeared in that matter. I will not, I would also say that, the senior advocate certainly for a matter will certainly not lie. But I don't want him to get into this controversy. I know that neither I'll be in a position to request your court to believe a senior advocate as against the proceedings recorded by the court.
Could have made a simple application for.
I understand, this. There is, may just
allegation against the judicial officer. This is not.
May make this request, I will unconditionally withdraw all the allegations, which is, there is no allegation as such, If your lordships were to see the affidavit, there is no allegation. They only record the court proceedings and say that since the court suggested we'll have to re-examine the witness, permit us to re-examine the witness. Kindly see, I have not. Your lordships may kindly take the affidavit,
Come to page number 62.
Please,
Senior advocate who has sworn an affidavit.
Please. Please,
Yes, read it.
the Honorable Court was pleased to direct us to re-examine PW1 on the said points in the next date of hearing.
Before that, V
Yes,
and PW1.
PW1 had brought to the notice of the Honorable Court with regard to mistakes stepped in the deposition before signing the deposition. The defendant has not consented for correction in the deposition.
Correct, you could have filed an application on the same day itself.
Notes,
Wherein
that is the,
application was filed after 8 days.
notes, that was on the next hearing date itself, notes. Right, this is the next sentence, notes. Notes, may I just make this request, notes. Let, if there is some mistake either on the part of the advocate.
Want a disposal, I'll dismiss it.
Lordship, so I'll take my chance in the first week of March.
Let the petition be listed in the second week of March.
Sorry, my lords, I took your lordship's time.
Injunction.
User of the court record. And so that the online app did not reflect the no uploading was done on the online app. It was only column or only those who had the matter was taken from the end. But we gave on the argument was taken for arguments not of the sorry, this is so practical for the commissioner. But then the matter was posted on 10th of the 10th people who are free by the people who have the matters. Your commission was direct, but it's possible. But then needs was suggested. In 1%. There was 2 marks.
Showpiece of the year, which year? Last more than 16 years suit is pending and order sheet speaks. When a commissioner was appointed, come to annexure K, it is an extract of a order sheet.
This is the online statement that was taken out from the online. In fact, the application was filed. You were both of them have filed different suits. Your application was filed in 35. No reference was made in 55. Instead, the same was recorded in 15/1/2004, where I appear for the defendant. In fact, the application was filed in 35. But in the entire order sheet, but in the online section, everywhere it was column. You do not have a personal provision of in late February, you have to think about
Correct, the order was passed for appointment of commission, but you have not taken any steps. Correct, you have not taken any steps.
You are watching the online statement, online app. Unfortunately, the online work was not uploaded. What was uploaded, not posted. The orders have not been done. So we from that word, you can think column next day, column. The other side, council also were on that aspect.
Correct, sir. Suit is of the year 2004. And on 8/2/2022 and then on 10/2/2022, none appeared on behalf of the parties.
On 8, we did not appear. There are 10. We appeared before the prior. But it was taken 301 because I was there in 305. One was the deputy council was present.
It is posted for judgment. When a case is posted for judgment, no applications can be imputed. Don't file an application before the trial court. And where is the order?
The next page. Page number 64. Copy of the order.
It is an advancement application.
I understand the advancement application of the law back was taken up on the part. Only then we will discard it.
The government counsel for the petition notice to respondent. In addition, so and so on the text. To file a collect correspondent for the learned counsel for the petitioner and also learned counsel for respondent. What do you say?
I was present.
Address your argument on the merits of the case before the trial court. No question of appointment, taking a steps against the commissioner and all those things. Correct. When you have not taken a steps, the matter has been posted for argument. So that extent I will set aside the order, otherwise. Virtually it is a collusive suit. Yes, plaintiff and defendant are colluded, and moreover, they are not addressing the argument on the merits of the case. So please, sir, kindly go through the order sheets. Yes. So this order sheet.
I have recorded in this case to the council took this practice, and then I have come out with
Matter is of 2004. The address argument and the merits. When an order was passed in your favor, you are not ready to take a benefit of that order, and you want to prolong the matter. Matter is of 2004. If you want to address argument on merits, I'll permit you to address the argument on merits before the trial court. If you want to take a steps, then let the court shall proceed with the judgment. Correct, sir. Nobody has prevented you from taking the steps. The court has prevented you from taking the steps. Correct. Suit is of the year 2004, sir. Petition. Being agreed with the order, and the petitioner agreed with the order dated 14/2/2022. Passed in OS number 15192 of 2004. Connected with OS number 3538 of 2004. Void annexure J. has filed this writ petition. Brief facts leading rise to filing of this writ petition are as under: the petitioner filed a suit in invoice number 15192 of 2022. Petitioner filed a suit in invoice number 3538 of 2004 for the relief of permanent injunction and also sought for a mandatory injunction directing the respondent to demolish the structure put up with the obstruct free flow of air, light and ventilation and movement in the ground floor and other reliefs. First up, the respondent has also filed a suit invoice number 15192 of 2004 for the relief of permanent injunction, restraining the petitioner from objecting, preventing, and obstructing the petitioner from constructing in the suit scheduled property and also sought for other relief. First up, in the suit filed with the petitioner filed an application for appointment of court commissioner to conduct a local inspection. The said IA came to be rejected by the trial court. The petitioner agreed with the order on the said application, filed a writ petition in WP number 31410 of 2010. First of this court, void order dated 12/7/2010 allowed the writ petition and set aside the order passed by the trial court and consequently allowed the application filed with the petitioner for appointment of court commissioner to conduct a local inspection. First of the parties, after suggesting several names for the appointment of court commissioner by both the sides, finally the petitioner suggested two names in IA number 13 and respondent suggested one name in her objection. First of, after hearing the matter, the trial court has posted the matter for orders and no such order was passed on IA number 13. No such order on IA number 13 was not forthcoming, stroke uploaded in the internet and e-court services. Instead, the uploaded statement was reflecting only as a call on. However, on 8/2/2022, the trial court posted the matter for argument after recording the order passed on IA number 3 is not complied with, and also adjourned the matter to 10/2/2022 and recorded that counsel appearing for the petitioner and also counsel appearing for the respondent remained absent and taken the argument as heard and posted the matter for judgment on 21/2/2022. So the petitioner filed an application for advancement and also filed an application seeking a permission to take a step for the court commissioner. First of the respondent counsel endorsed on the said application as no objection. First of the trial court has recorded a finding that first of the trial court rejected the applications filed by the petitioner, hence this writ petition. Order the learned counsel for the petitioner and also learned counsel for the respondent. Learned counsel for the petitioner submit that the petitioner has filed an application seeking for appointment of court commissioner to conduct a local inspection. The same came to be allowed by this court in the aforesaid writ petition. He submit that due to SOP issued by the High Court, the counsel appearing for the petitioner could not able to attend the court physically. Hence, the petitioner and respondents were not aware about the order passed by the trial court on IA number 13. Hence, for the said reason, the petitioner could not able to take the steps. Hence, for the said reason, he submit that the trial court, without hearing the arguments on both the sides, posted the matter for judgment. Hence, he prays to allow the writ petition. Per contra, learned counsel for the respondent submits no objection to allow the writ petition. Heard and perused the records and considered the submission of the learned counsel for the parties. It is not in dispute that the petitioner and respondents have filed suits and the said suits are pending. In the said suit filed with the petitioner has filed an application seeking for an appointment of court commissioner to conduct a local inspection. First of the said application came to be rejected by the trial court. First of the petitioner agreed with the order filed a writ petition in WP number 31410 of 2010. First of this court wide order dated 12/11/2010 allowed the writ petition and consequently appointed a court commissioner to conduct a local inspection. First of the trial court the first of the trial court has adjourned the matter to suggest the name of the court commissioner. First of the petitioner filed an application that in IA number 13 suggesting two names, and respondent has suggested one name in her objection in the objection. First of the trial court, after hearing the arguments on IA number 13, has passed an order on 4th January 2022. First of this court, the High Court has issued a SOP preventing the advocates from entering into the. This is the only reason now I have to say. This court has issued a SOP wherein due to increase in the COVID-19 patients, the advocates are prevented from entering into a court premises. First of the trial court has passed an order wherein further the petitioner has produced a copy of extract of day-to-day proceedings as uploaded in the internet e-court service app in OS number 3538 of 2004 as per Annexure K. From the perusal of Annexure K, it does not indicate that the trial court has uploaded the order passed on IA number 3. First of the as the said order was not uploaded in the website. In the website, the petitioner could not be able to take the steps. The trial court, without considering the said aspect, has directly posted the matter for arguments, and considering the absence of the learned counsel for the parties, posted the matter for judgment. Thereafter, the petitioner filed an application to file an application seeking permission to take the steps as per the order passed on IA number 13. First of the trial court has rejected the said application. First of the trial court, without considering the said aspect, has proceeded to pass an impugned order. The impugned order passed by the trial court is arbitrary and erroneous. Hence, on this ground, the writ petition is liable to be on this ground, the impugned order is liable to be set aside. Accordingly, proceed to pass the following order. Writ petition is allowed. Impugned order is set aside. Petitioner is directed to take the steps within a period of 8 days from today, failing which the petitioner shall not be entitled for the benefit of this order. After for full stop further, the suit is of the year 2004. The trial court is directed to dispose of the suit as expeditiously as possible. And so undertakes to file a wakalat, is permitted to file a wakalat within a period of 15 days. Yes, Sumesh.
My lord. Notice me that.
If you notice the respondent. Oh, you do not want to argue the matter?
My lord.
Huh? Yes, sir. Come to para 14 of the impugned order. Yes. Come to para 14. Page number 49. Two piece form. You should notice the respondent. You should notice the respondent.
Srimati Shilpa Shah.
Lord, I appear for the petitioner in this matter. Lord, here we have challenged the order passed by small causes court allowing impleading application, whereby 3 officers of NHI were impleaded, my lord. Now, my lord,
To the petitioner, you should notice the respondent. In addition to the petitioner is permitted to serve a copy of his petition along with the annexes on the learned counsel appearing for respondent before the transfer. There shall be a stay of operation of the impugned order till next date of hearing.
oblige, my lord.
14 and 15 same.
Lord, that is identical matter. my lord.
Same, madam, same order.
Sagar.
Obliged, obliged.
An application but that application not rejected, and the doesn't appeal not the part of rejection of the application.
No, already final decree has been drawn now.
Whereas the contention of the not all they are related, they do not come to the joint family. And the property are not there. But in spite of that, the very same process of products are also very close to the same petition.
Respondent petition number 3 appeared and did not choose to file a written statement.
Defendant number 1 not separate as not of the defendant number 4 not to go to very court. Now they filed execution.
Correct, whether the petitioner had benefit, whether the appellant had benefit of interim order in the.
The dependency of the execution was not filed. The matter was not distributed. Now, the execution is filed and the matter is distributed on 25th. So, they were to execute not my way.
Correct, sir. Now, preliminary decree came to be passed, final decree came to be passed.
Anytime not within the time provided not.
Report or notice.
I take a time.
But this is a execution of a decree. How can we grant an order of status quo? It's not a property. Impugned order.
That is why not a proper state. Now, my offense and disclosures not
We can restore it. No. We should notice to respondents. In addition to it, petitioner is permitted, appellant is permitted to serve a copy of appeal memo on the counsel appearing for respondent in execution petition number
30 of 2021.
20 of 21 pending on the file of. Let the appeal be listed on the second week of March.
Serial number 17, Shri H.P. Leelagar.
Maintain status quo till the disposal of suit.
And it should be directly disposed of then control.
Correct. Now, who is making an attempt to construct a building? Who is making an attempt to construct a building? Huh? Suit property is a vacant site only.
Actually, it was not a vacant site. House was there and it was there and we removed with the intent construction. And that was a very basic and that helped the kind of and they feel it. But there is the right law on the sale of your which is the landed property of certain particular and my claims are that fathers were structured Indian entity size from the mother-in-law of the appellant. Pursuant to that,
Are you ready to give an undertaking that in case if the plaintiff succeeds in the suit, will not claim any equity? Learned counsel for the respondent seeks time to file an undertaking that stating that in case if the petitioner appellant succeeds in the suit, the respondent will not claim any equity, for which the learned counsel for the appellant submit that he has no objection for it. Let the appeal be listed on Monday. Monday, it will be discussed on Monday. Allah, when he ready to ask, Allah, if he files an undertaking that appeal can be on that.
My lord, I represent KV respondent number 2 in this matter, my lord.
Membership. Suspension of membership.
There is suspension in court for 1 year.
Better take this matter in the first week of March. Whether had you a benefit of interim order before the trial court? On the ground of misappropriation. Yes, Divakar sir, you take matter before. Sir, it doesn't make any difference within a where are the report? Sir, the request of learned counsel for the respondent, let the petition be listed on March. Doesn't make any difference, sir. doesn't make any difference. Correct, but he's saying something else. What you have produced is contrary to the submission. By only one of the.
Even the police complaint, what they say, there is no name of the
Consider it on second. We consider it on second.
Number 1926, first time complaint.
2 weeks time granted to comply with office application.
Serial number 27, CBS Ravindra.
Is not maintainable, you have to file appeal before the district court. I permit you to file appeal before the district court. It is pending since from 2019. Then why unnecessarily want to keep the appeal pending? The petitioner, the appellant, being agreed by the order dated 5th July 2019, passed in miscellaneous number 47 of 2016 by the Principal Senior Civil Judge and JNFC, Chikballapura, filed this appeal to stop the impugned order passed under Order 41 Rule 19 to stop the subject matter of the suit property is less than 10 lakhs. The appeal filed by the appellant before this court is not maintainable. The said appeal lies before the district court as per section 19 of Karnataka Civil Courts Act, section 19(1) of Karnataka Civil Courts Act. To stop in view of the same, the learned counsel for the appellant seeks permission to withdraw the appeal with the liberty to present it before the proper forum. Submission is placed on record. Appeal is dismissed as withdrawn with the aforesaid liberty. Registry is directed to return the certified copy of the impugned order after retaining the photocopy of the same.
Serial number 28. Honorable Respondent.
Petitioner by me. Lordship, I have taken the notices to all the respondent but for the respondent number 8, and I filed a memo praying this honorable court to dispense with the notice to respondent number 4, 5 and 6 who are placed ex parte before the court below and who never appeared before the court. That is the second memo, my lord. 4, 5 and 6.
The counsel for the appellant has filed a memo stating that as per the order dated 8/2/2022, has served a copy of appeal memo on the counsel appearing to respond number 1, 2, 3, 7 and 8 in the trial court, appearing before the trial court, and produce the copy of acknowledgement, and same is placed on record. Further, learned counsel for the petition appellant has also filed a memo for dispensation of notice to respond number 4, 5, 6. Memo is placed on record. Notice to respond number 4, 5 and 6 is held is dispensed with at the risk of the appellant. Further, service of notice on respond number 1, 2, 3, 4 and 8 held sufficient. Registry is directed to print the name of respond number 1, 2, 3, 7 and counsel appearing for
PC Sriram Reddy 1, 2, 3.
1, 2, 3, 7 and 8, my lord.
Then the registry is directed to print the name of respondent number 7 and 8 in the cause list, and also counsel appearing for respondent number 7 and 8 before the trial court. Let the appeal be listed in March.
First week, my lord. Second week, the matter is posted before the court below, my lord. First week.
My lord, I appear the appellate in this matter, my lord. My lord, since this office objection with regard to the valuation, my lord, I will place the valuation slip and thereafter it may go to the division bench. Therefore, my lord, I seek time, my lord. 30 lakhs is the valuation. Please.
Learned counsel for the appellant seeks time to comply with office objection.
1 week's
2
time.
weeks time granted to comply with office objections.
Please, please, my lord.
Serial number 30. P.D. Prakash.
But proceedings are under the arbitration act. Section 34 was filed against the award passed to the deputy commissioner. Circular. Commercial Court Act.
Is it serial number 31, my lords?
30.
Sorry, my lords. I'm sorry. My apologies.
But correct, this application was entertained by the commercial court. Correct now. Correct, sir. Now commercial court has passed this order. For that reason, office has raised objection. You could have challenged that order of conversion. Learned counsel for the petitioner seeks time to comply with office objection. Seeks time to comply with office objection. 2 weeks time granted. Correct, sir. That order is passed with the commercial code. Section 17, 13. Maybe. Any order or decree passed by the commercial court, appeal lies under section 13. The appellant being agreed by the.
Does this pertain to serial number 31, my lords?
Passed by the commercial court. Commercial court in arbitration petition number 3 of 2020 has filed this appeal. Office has raised the objection in regard to the maintainability of the appeal in view of circular dated 30th October 2017 issued by the High Court, wherein the circular indicates that any any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order Full stop. Further, as per clause 1A of section 13, if any person agreed with the judgment or order of a commercial court at the level of a district judge exercising original jurisdiction, or as the case may be, commercial division of a high court may appeal to commercial appellate division of that high court within the period of 60 days from the judgment or order. To stop in view of the same, the appeal filed by the appellant is not maintainable. Office objection is upheld. However, learned counsel for the petitioner seeks permission to convert this appeal into commercial appeal. Filed a memo for conversion of the MFA into commercial appeal. Memo is placed on record. Registry is directed to permit the appellant to convert the MFA into commercial appeal for statistical purpose. Appeal is disposed of. Learned counsel Sri D.S. Jairaj has filed a memo for retirement. Learned counsel Sri Shankar P. Hegde has entered appearance. In view of the same, memo filed by the learned counsel Sri D.S. Jaikumar is placed on record. He is permitted to retire from the case for the appellant. Registry is directed to delete the name of Jairaj D.S. for the petitioner.
And for the respondent in this matter, my lords, the order imputed is an order passed by the commercial court at the district judge level. Annexure A, my lords, page 36 is the order.
You are addressing the argument on merits?
But I'm for the respondent's counsel, my lords, in this matter.
Yes.
Petition's counsel is also present. This is writ petition is filed, my lords. This is a writ petition which has been filed against an order passed by the commercial court. Annexure A, page 36 is the order. The plaintiff is returned for non-compliance of section 12 capital A. It's an appealable order, my lords, in terms of section 13.
Yes, counsel. Shankar Hegde.
Shankar, unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Lords, the suit has not yet been numbered, and I am appearing for the counsel. I am a proxy counsel appearing for the counsel for petitioner, my lords. If it may be had on a different date, I will instruct the counsel for the petitioner to appear before this honorable court.
Yes,
it is seemingly, my lords, covered under section 13. There is no doubt, but I am not in a position to concede anything before this honorable court in view of my limited jurisdiction.
Taken up next week, my lords, is the only question.
At the request of learned counsel for the petitioner, let the petition be listed in the second week of March.
Lords, until then, an interim order which has been granted may be extended, my lords.
I have an objection for the interim order to be extended for this reason, because it was only a return of the plaint. Lords, in that an interim order has been granted, not to
be removed from record. That's all, my lords.
Correct, Ravi Shankar. Already this court has granted an interim order.
I understand that was an ex parte order, my lords, which we have sought for vacating. But nonetheless, my lords, your lordships may accommodate on an earlier date. I will not say anything further, my lords.
Second week.
Very well, my lords. As your lordship pleases.
Interim order is extended, my lords. I'm sorry.
Yes, it is extended.
Much obliged, my lords.
My lord, serial number 32, my lord. I am for the petitioner in this matter, my lord. My lord, I am audible, my lord.
Yes. Wait.
The writ petition and its annexures have been sent to the post, my lord. Moreover, my lord, I have completed the office objection.
Yes.
My lord, petitioner is the LR of the dependent number 3, my lord. The plaintiff.
Complete the office objection.
My lord, I have complied the office objection. If any objection is rises, my lord, subsequently I will comply, my lord. More.
Comply the office objection.
My lord, matter is urgency, my lord. Notice may be issued, my lord. Suit for declaration and possession, my lord. My lord, during the pendency of the suit, my lord, the dependent number 1 was died. After death of the dependent number 1, my lord, the plaintiff filed the LR application, my lord. After allowing this application, my lord, the petitioner came and record, my lord. After coming on record, my lord, the petitioner has filed the application under section 151 of CPC for permission to file a WS, my lord. Said the application has been dismissed by the trial court, my lord. For avoiding the multiplicity of the proceedings, my lord, I have challenged the said order, my lord. Permission has not been granted to file a WS, my lord.
Yes, who appears for Kevita? Awesome.
I beg to appear for appellant in this case, my lord. The first defendant, my lord, Bangalore, the Commissioner, Bangalore Development Authority, I have filed a memo and deleted, my lord. And another objection, my lord, I have complied it, my lord.
Learned counsel for the appellant petitioner submit that he has complied with the office objection, office to verify. Let the petition be listed in the second week of March.
My humble request, my lord, matter is very urgent, my lord. Only amendment I have sought, ma'am.
Correct. The requisition was filed in the year 2021.
Yes, my lord. Because, my lord, due to some office, Corona, file ನನಗೆ ಸಿಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಕಂಪ್ಲೈ ಮಾಡಬೇಕು
ಫೈಲ್ ನಿಮ್ಮ ಹತ್ರ ಇರುತ್ತಲ್ವಾ ನಿಮ್ಮ ಆಫೀಸ್ ಫೈಲ್ ನಿಮ್ಮ ಹತ್ರ ಇರುತ್ತಲ್ಲ
ಅಲ್ಲಿ ಆಫೀಸ್ ನಲ್ಲಿ ಮಾಡಕ್ಕೆ ನಮಗೆ ಪರ್ಮಿಷನ್ ಸಿಗ್ಲಿಲ್ಲ
ಯಾಕೆ ಸಿಗ್ಲಿಲ್ಲ ಯಾಕೆ ಆಯ್ತು ಮಾಡಿ ಮಾಡಿ ಮುಂಚೆ
34
ಥರ್ಡ್ ಟೈಮ್ ಇದೆ ನಾಟ್ ದ ಫಸ್ಟ್ ಟೈಮ್
I am for the petition matter, my lord. The office objection only annexer D to be stitched horizontally, my lord. That's all, my lord. Annexer D to be stitched horizontally. That's all, my lord. That is office objection.
I've seen the office objections.
Yes, my lord.
Serial number 1, respond number 1 and 3 are the same party.
Yes, respond number, my
clarified.
lord.
Have you clarified
yes, yes, ma'am. Respond number 1 and 3 are different, my lord. But respond number name is Siddhaya. Respond number 3 name is M Siddhaya. Both the sons of the Mariappa. Both are different. It is reflect in the OS on the final decree and client also, my lord.
Number 4 is
Petitioner is Siddhaya.
In the client annexer A, my lord. Page number 10. Client is Siddhaya and different number 2 M Siddhaya. Both are brothers, my lord. In this petition, my lord, the respondent number 1 may I argue, my lord?
so far as office objection number 1 is concerned, office has raised the objection in regard to respond number 1 and 3 are the same parties to be clarified. Learned counsel for the petitioner submit that the respond number 1 and 4 are the sons of late Mariappa, wherein respond number 1 name is shown as Siddhaya, wherein respond number 4 name is shown as M Siddhaya. There
three, my lord. Respond number 3.
Respond number 3. Respond number 3. They are different. There are different persons and their age is also different. Submission made by the counsel for the petitioner is accepted and office objection insofar as serial number 1 is concerned, it is overruled. What about number 2?
Number 2, my lord. Annexer D to be stitched horizontally.
Signature of petitioner number 4 is not tallying with the first title to be clarified.
Yes, my lord. But her name is Her name is Netravati, my lord, but the signature petition number 3, my lord, Netravati.
Petitioner number 4 is Srimati Sudha.
Yes, my lord.
Then comes for the petitioner seeks time to comply. Office
My
of
lord, it is the urgency, my lord. My lord, it is the urgency, my lord. The delivery warrant also issued to the petitioner, my lord.
35, my lord, I seek 1 week time to comply the office subtraction. I will serve the copy to the
Lord, any date may be fixed, my lord. Serial number 34.
Business filed IA-1 of 2021 for posting the petition, accepting the reasons assigned in IA-1 of 2021. IA-1 of 2021 is allowed. Let the petition be listed on 7th March.
Sorry, my lord. Serial number 34, my lord.
7th March.
11th March. Much of
7th.
Much of
35, I appear for the
35,
respondent.
my lord, I am for the petition, my lord. Seek 1 week time to serve the copy to the caveat.
Please, my lord.
Learned counsel for the petitioner seeks time to serve a copy of her petition on the counsel appearing for the caveat. Let the petition be listed in the second week.
First week of March.
Is permitted to serve a copy of his petition along with the annexures on the counsel appearing for the caveat. Let the petition be listed in the second week of March.
First week, man. First week.
Serial number 36. Mumbi Chandrasekhar Reddy. Serial number 36. Mumbi Chandrasekhar Reddy. Mumbi Chandrasekhar Reddy.
None appear for the past. Listed in the second week of March.
Serial number 37.
My lord, I am appearing for the petitioners in this case, my lord. I seek 2 weeks time, my lord, to place before the this honorable court some documents, my lord.
Learned counsel for the appellant seeks time call after 4 weeks. Is there any entry model, sir? Whether any entry model is there?
Entry mod is in favor of the respondent, my lord.
Pleading. Learned counsel for the respondent submit that the respondent has filed an objection to the stay petition. I filed objections to IA-2 of 2022. Office to verify and put up the objections. Yes, fine.
I'm appearing for petitioner, my lord. I filed application for extension of time to comply the interim order, my lord. The honorable court have directed to deposit 50% of the decreed amount, my lord. Yes, 2 weeks time, my lord. Due to the COVID, my lord, I am unable to arrange the amount, my lord. Within 2 weeks, I will deposit, my lord.
First to get the demand draft, then thereafter we'll consider the extension of interim order.
No, I will deposit before executive court, my lord. Within 2 weeks, I will.
First to bring a demand draft. First to bring a demand draft.
Next week, my lord, and the date may be.
When this order was passed?
On 14/2, my lord. 14/1, my lord. 14/1, my lord. I have got the certified copy on 28/1, my lord. And thereafter, due to COVID, my lord, I am unable to arrange the amount, my lord.
Counsel for the petitioner seeks time. The petition be listed in the second week of March. Await service of notice in respect of respondents. Release the release the petition after receipt of service of notice on respondents.
Petition matter, serial number 40, should be taken. Case B number R2.
For the respondent number 2, my lord, the copy as directed to this honorable court, the judgment and award copy has not been served to me till today, my lord.
Have you got any objection for IA1 of 2014?
I leave to your lordship, my lord, any terms it may be allowed.
Appellant filed IA1 of 2014 seeking for condemnation of delay of 214 days in filing appeal. The respondents have not filed any objection to IA1 of 2014, accepting the reasons assigned in IA1 of 2014. IA1 of 2014 is allowed. Delay of 214 days is condoned in filing appeal. Let the appeal be listed for admission.
My lord, letter be again directed may be issued as directed by this honorable court. He has not served the copy, my lord, that is the judgment and award.
Learned counsel submit that the appellant will serve a copy of appeal memo, copy of judgment and the award passed by the reference court.
Appeal memo I am having.
On the counsel on the government advocate.
Respondent number 2.
Everyone, it's Ananda Krishnamurthy. V. Mohan Rangam, respondent.
Along with documents.
Pardon? You want to go through it? Petitioner, appellant has filed a memo along with the documents. Same is placed on record. Learned counsel for the respondent seeks time to go through the records. Let the appeal be listed in the second week of March. Second week of March.
Serial number 42, Mediation Shankar Indra IAS for Mediation Arthur.
Just a minute. 2 minutes. 2 minutes. Please take your seat. Okay. Please take your seat. I'll go through. Yes, sir.
I find the two. The case will not respond.
Now the question is,
Who's in possession? That says you will not money allowed because I will not, my suit was degree. They said to us that I will possession. Please get not his or he filed.
that came to the discussion. But now the question is, he has initiated a proceedings under the PTCL Act. Under the PTCL Act. And
Somebody else, not against us.
not against a,
No.
against the appellant, your counsel against the appellant. And sale deed has been declared as a null and
My submission is not. There's not a document to show that I was very There's not particularly out.
no, but there is observation by the trial court.
Any observations are that's because my suit was degree. They find not a claim. In that part, if that part, and I just that is not what has happened is
Where is the document? ನಾವು ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಕೇಳಕ್ಕೆ ಆ ತರ ಇದ್ದಾರೆ ಅವರು. You should respect the seniors ಆ ತರ ಮಾಡೋದಲ್ಲ. ಎಲ್ಲರೂ ಆನ್ ರೆಕಾರ್ಡ್ ಅಡ್ವೊಕೇಟ್ ಅವರಿಗೆ ಇದು ಕೊಟ್ಟಿರಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅದಕ್ಕೆ.
I don't know. Each second thing on the document.
ಎಂದ ಹಾಕಿದಿರತ್ತ MFA ಯಾವ in which MFA you have filed? Date?
Hello.
Because I don't know.
That goes to the root of the case. If you say that the property involved in the PTCL proceeding is different, then the judgment and decree passed in his favor is in force and then it will come into force. Correct, sir. Property is the same property or a different property? The different ಅಂತ ಹೀಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು. Correct, sir. Proceedings, PTCL proceedings in respect of the property which is involved in the present suit or ಬೇರೆ ಇದೆ? Yes, it's okay, it's okay. Learned counsel for the appellant seeks time. Let the appeal be listed in the second week of March. Huh? Next week ಇರೋದೇ 1 week ಇದೆ. ನಮ್ಮ ಪೆಂಡಿಂಗ್ ವರ್ಕ್ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ಕೊಂಡು ನಾವು ಬೇರೆ ಬೆಂಚಿಗೆ ಹೋಗೋದಿದೆ. ಈ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದ್ರೆ ನಾವು ನಿಮ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಂಡು ಪಾರ್ಟೆಡ್ ಮಾಡ್ಕೋಬಹುದಾಗಿತ್ತು ನಾವು. Interim order granted earlier is extended. When interim order was granted? Huh? Have you filed an application for vacating? Have you filed an application for vacating? Have you filed an application for vacating? Then interim order granted earlier is extended till next date of hearing. Till next date of hearing.
Number 43, is by mediator respondent 16.
Only the subsequent purchases were repeated. The last case my lord noticed that the honorable learned cylinder also went on the rejection of
I number 4.
I have listed one other aspect of rejection. I have challenged the IN number 4 now as a matter of government precaution. Just we did not come into to operate in so far as this. But independently, I will do this. Of course, in the IN number 4, government is just I am not able to grab out this case. On the sole ground that I should believe. This is incorrect for the reason that the law should treat memo, which I find on
11.
Yes. The position IN number 4. We also kindly have a look at your page. In page 3.
Correct, but we have to hear both the application, both the appeals. Week after next.
Only apprehension not to any the suit for specific performance. The suit for specific performance, as it is agreed, I have paid 2 crores apart from conversion service. The only ground on which they say they are unable to perform, they say they can't get it converted because it is a little. This is now, of course, not the criteria, number 1. Number 2, either way now around by also the amendment to the Land Reforms Act, I get automatically in my agriculture. Those who cannot get
repealing of 79A and B.
Those who cannot get it. Now then the point is, can the learned civil judge say that suit is related?
The appeal is not before this. At the request of learned counsel, let the appeal be listed in the first week or second week. Second week.
The only thing is, again, you know, it's super special performance. It's not a case where 50 is a second directly come into play. In terms of section 19 of the specific act, the subsequent purchaser has to join in the execution of the sale with other purchase. And more particularly, this becomes a
provided if he proves that he is a bona fide purchaser.
So therefore, I will only bear also for a shorter competition.
Second week. Corrections file just did it.
Number 44,
My lord, I appear for the appellant in this matter. This matter will be taken at 2:30, my lords. I will reach the court by that time. So, 2 matters. On the last day, did not reach, my lord, and I was in another online court. I'll be reaching the court by 2:30, my lords. I'm ready.
Not at 2:30 today.
Sir, it is serial number 44. Gunjal sir. 44. Udita Ramesh. Or the 46.
Suit is of the year 2020, man. Question. He is given an undertaking that in case if you succeed in the suit, then you will not claim any equity. In view of the undertaking given by him, nothing survives for consideration in this appeal. The appellant being aggrieved by the order dated 2nd December 2021, passed on IN number 2 in OS number 25410 of 2020 by the 57th Additional City Civil Session Judge, New Hall Unit, Bengaluru, have filed this appeal. Brief and pleading as to filing of this appeal are as under the plaintiffs, the appellants have filed a suit for permanent injunction. In the said suit, the appellants have filed an application seeking an order of temporary injunction, restraining the respondent from putting up any construction or the suit scheduled property or A and C scheduled property. First of the trial court, the said application was opposed by the respondent. The trial court, after hearing the parties, rejected the application filed by the petition, filed by the appellant. Hence, this appeal, after hearing the learned counsel for the appellant, submit that if the respondent files an undertaking that in case if the appellant succeeds in the suit scheduled property, the respondent will not claim any equity. First of the learned counsel for the respondent number 6 filed a memo stating that the respondent number 6, without prejudice to the contention already raised and is right to contest the suit in OS number 25410 of 2020 and other proceedings that may be commenced by the appellants, hereby declares stroke undertake that the respondent number 6 shall not seek or claim equity on the basis of the construction stroke development made by him in the event the appellants finally succeeds to establish their claim made in OS number 25410 of 2020. First of the memo is placed on record. Memo of undertaking is placed on record in view of the memo filed with the in view of the memo filed with the respondent number 6. Nothing survives for consideration in this appeal. Accordingly, appeal is disposed of. You have disposal of appeal IA1 of 2022 does not survive for consideration.
Please, my lord, appear for the appellant in this matter. This matter may can taken at 2:30 minutes. I'll add another online matter.
46 serial number 45.
45 Gunjal, my lords. 45. What is it?
Sir, 46 is the tam case.
I'm sorry, my lord.
Gunjal sir.
Yeah, 46 is mine. I thought
you know, count 45 there.
Oh, the 46 now. Sorry, my lord.
Okay.
The case of the thing, and is surveillance of 133 was granted to my father under the Injunction. He found a revenue layout, and one of the sites, site number 73, size form survey number 133. My father has gifted this property, the site number 7 of my sister, in the year 2001 under the registered gift. And then, my lord, the property was rented into joint family, and there was a partition between me and my sister. And this property has allotted to me, has been allotted to me. And by virtue of that, what I am the owner in possession of the city property. The defendant, on the basis of safely executed by one Lakshmana, in his favor, who is none other than his mother, is claiming title to the property and also possession to the property. Therefore, I have to take a suit for intention restraining his from putting up any construction, because there is no right to pass under the state. Now we have produced before the time court we produced two documents. One is general cause of crime, said to have been executed by my father in the year 1993, and the affidavit, and contains that he is in possession of the property. My submission, my lord, that 1990 power of crime does not give it power because 2001 my father has already alienated the property in the case file. So therefore that power of attorney will not ensure to the benefit of the defendant. The defendant's mother to execute the same in the year 2017. When we see the 2017 saving what my amendment has produced the law no. Even according to the saving, you were putting possession in 2017. And my sister was put possession in 2001 under the registered decree. And thereafter there was a compromise between the partitions and I got the property. While court has completely misread the document and say that defendant is in possession of the property.
The father of the party in OS number 5646 of
Right after his death, between me and my sister, the party. And this property came to me under the partition. By that time, my father was alive. This particular.
when your father has gifted the property in favor of
2001.
where is the pleading of
But that pleading will not affect my. The trial court itself says, "Pending seen not to be." Panel amendment. No doubt the plaintiff is supposed to claim God produced the copy of the layout plan formed by his father in the land that he wanted to be was wherein the revenue layout was formed by his father during his lifetime. Apart from the said document, plaintiff also got produced copy of the decree executed by his father in favor of Sultan Mahmud, son other than invested specific property and also got a certified copy of from
That was also subject matter of suit in OS number 5646.
yes. And the blended and ultimately by way of settlement, the site has come to me. It is under the compromise decree 56.
So gift deed will become redundant.
Not become redundant, or they have accepted that okay, we also
Correct, but subsequently that has that was a subject matter of suit in OS number 5. Now you are
property was included for the purpose of settlement. So
there is a
therefore,
compromise decree in OS number 5646.
but I have produced along with the actual, I have not produced yet. Produced in the suit. The Brahma will be second dependent and the third dependent. The lordship will find at page 48. Item number 1 is the suit clause. As far as not page 40, page in page 10.
Survey number?
133/1, site number 73. Site number 73, survey number 133/1. Page number in page 10. The internal page. Item number 1. And my father died on 29/1/2002. Before that, he executed a gift deed on 19/10/2001.
Gift deed is of the year 2001. Power of attorney is of the year 1993.
But the power of attorney, according to them, they have explained the power, assuming that it's a valid power of attorney, power of attorney. In 2017, they are claiming title to the scheduled property on the basis of sale deed of 2017. So therefore, no right flows under the sale deed. And sale deed says this defendant was put in possession on that day. So in 2001, my sister was put in possession, thereafter it came to me. So no question of possession, delivery of possession under the sale deed of 2017. And under the power of attorney, no possession, not a registered power of attorney. Another important thing is what in the sale deed, they don't mention about the power of attorney. They mention under the registered deed of 1990, this vendor of the defendant has got the property. There is no registered deed of 1990.
Yes, sir.
Open injunction. It not compulsory. Keep this. Yes, you have 30 to 35 years. There are same way, 70, number 71 has been sold by the father of the act. In form. Has consented to building based on the GP and upgrade.
Now, subject matter of the suit property is site number 73. Whether father has a
And thereafter, this lady now, give the speech and also declare forward. And you have put up construction.
where is your sale deed? Where is your sale deed?
Move along with the
23.
important matter, see photograph. You need to find a new position. Plating will not in position. No need
Yes, yes, yes.
I can find only bare injunction. We are not having my stated or position to me.
Construction, what happened to all, they were in on partial character. And I complained with the order. The amendment has appeared on the next day itself. But while court, in spite of applied, while court has vacated the entry order, did not continue the entry order. Taking advantage of it, what they have put up this construction. So therefore, it is not that.
No, you are not in possession. It amounts to.
Not in possession, but only the presence of the suit. It's a force which is taken.
No point of time.
NPC is saving. NPC is saving, which is produced. And Lakshmana executes in favor of.
Correct. Any construction undertaken by him shall be subject to the outcome of the suit. Now he has already constructed the.
Section 48 of PE Act. ILR 2015 Karnataka Judicial 16.
Sir, it is settled law. A person who is not in possession of the property is not entitled for.
Where I will go, my other, I paid 25,000 in 1990. But full consideration, he executed agreement. No one has been challenged.
Before purchasing a property, have you made an inquiry about the title deeds? Nil encumbrance. Have you seen the nil encumbrance? Before purchasing a property. My lord, bidi ನೀವು ನಾನು ಏನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟು ಹೇಳಿ ಅಲ್ಲ section 55 of TP Act ನೋಡಿ rights and liabilities of purchasing. Section 55 of TP Act ಓದಿರಲ್ವಾ ಸೊ ಗಿಫ್ಟ್ ಡೀಡ್ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಇರುತ್ತೆ ಇಲ್ವಾ ನಿಲ್ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ಡ್ ಇತ್ತಂದ್ರೆ ಇರ್ಬೋದಲ್ಲ ಇರುತ್ತೆ ಯಾವುದೇ ರಿಜಿಸ್ಟರ್ಡ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ಎನಿ ರಿಜಿಸ್ಟರ್ಡ್ ಇನ್ಸ್ಟ್ರೂಮೆಂಟ್ ದಟ್ ವಿಲ್ ರಿಫ್ಲೆಕ್ಟ್ ಇನ್ ದ ನಿಲ್ ಎನ್ಕಂಬ್ರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ
Dhoni, she's not claiming any right over my property.
It's also reflected. The decree is also registered.
He is in possession now, he has already put up. ಅಲ್ರಿ ನೀವು ಫೇವರ್ ಮಾತಾಡಕತ್ರ ನೀವು ಹಿಂಗ್ ಮಾತಾಡಿದ್ರೆ ಒಂದ್ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಬಿಡೋಣ.
Let them not continue the construction. Let them get direction to transport dispose of the matter. Let them not complete the construction.
Now he has already constructed substantial portion of construction is
During the potential.
correct. Let him file an undertaking that. ಆಯ್ತು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತೀರಾ? ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡ್ತೀರಾ? ನಾಳೆ ಮಂಡೇ ಅಂದ್ರೆ then we'll grant the status code to maintain. ಅದೇ ಮಾಡಿ ಆಮೇಲೆ ನಿಮ್ಗೆ ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಫೈಲ್ ಮಾಡಿ ನಾನು ಸ್ಟೇಟಸ್ ಕೋ ಕೊಡ್ತೀನಿ. ಅದೇ ಯಾವಾಗ? ಮಂಡೇ ಇಲ್ಲ ಮಂಡೇ ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ. ನಿಮ್ ಕಲೀಗ್ ಇರ್ತಾರಲ್ವಾ? Parties are directed to maintain. Third, the learned counsel for the party, learned counsel for the appellant submits that the appellant, the respondent taking undue advantage of the impugned order is proceeding with the construction or the suit shall property if the respondent is permitted to proceed with the construction of the suit shall property. The petitioner will not be in a position to execute the decree that may be passed in his favor. Hence, in view of the same, in order to preserve the property, it is just and proper that Monday haki, another status quo. ನಾಳೆ ವರ್ಕಿಂಗ್, ನಾಳೆ ಆಫೀಸ್ ವರ್ಕಿಂಗ್ ಅಪ್ ಟು 1:30 ತನಕ ಇರುತ್ತೆ, ಆಗ್ಬೋದಾ? Then the counsel for the respondent submit that the respondent will file an undertaking stating that in case if the appellant succeeds in the suit, the respondent will not claim any equity. If submission is placed on record, he is permitted to file an undertaking. Let the appeal be listed on Monday.
Shortly, my lords. 2:30, I'll reach the court shortly, my lords.
Not at 2:30, sir, on some other day.
46 and 48, both are my matters. I was another online court. And by the time I could reach, my lord, I could not be able to reach the court, my lords.
Not at 2:30, sir, on some other day.
Monday. There is urgency in this matter, my lord.
Let the appeal be listed on Tuesday.
Kindly grant a date, my lords. 46 and 48.
22nd.
Much obliged.
47.
I beg to appear for petitioner, my lord. The matter was ended with compromise, my lord, before the FDP court, my lord.
49 is also same.
Properties are divided, my lord. Among
Serial
all
number
the
49 is also same, algo?
Yes, my lord. Both are same.
Issue notice to respondent. Serial number 47 and 49.
Interim order of stay, my lord. Allah, status quo ಕೊಟ್ಟದ್ರಿಂದ agriculture land I can't.
ಆಫೀಸರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
My humble request, my lord. They are my brothers, my lord, residing at Mysore and Bangalore, my lord.
ಸರ್ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ ನಾಯಕರೇ.
ಸ್ಟೇ ಕೊಡದ ಇದ್ರೆ ಅಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ, ಅದಕ್ಕೋಸ್ಕರ
ಆಯ್ತು ನೋಡೋಣ, ಬನ್ನಿ ಮುಗಿಸ್ಬಿಡೋಣ.
ಡೇಟ್ ಮೇ ಬಿ ಫಿಕ್ಸ್ ಮಾಡಿ
ಸರ್. ನೋಟಿಸ್ ಆಗಿದೆ,
ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಕೌನ್ಸಿಲ್ಗೂ ಸರ್ವ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಹೂ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಬಿಫೋರ್ ದ ಎಕ್ಸಿಕ್ಯೂಟಿವ್.
Issue notice to respondent. In addition to it, appellant is permitted to serve a copy of appeal memo on the counsel appearing for respondent before the trial court. Let the appeal be listed in the second week of March.
Challenge the issued order dated 23/12/2021. The judiciary judge has wrote the entry application filed by the plaintiffs regarding the matter where injunction was sought for by the plaintiffs, restraining the defendant not to air the program in the TV channel on the pretext that it is going to be derogatory remarks to the last LNS. And it is the entire supervision is filed an apprehension that his name, his character will be defamed and there will be some derogatory statements made. Perhaps the entire program was to be made by the defendant or on a transaction which happened where perhaps the land which was allotted to one partnership firm called Shamba Industries. Perhaps the previous partners who had filed their claim petitions before the LLC proceedings perhaps. In that case, they had filed claim petitions for compensation. But subsequent to that, BDA acquired the properties to form the further extension of the Mahalakshmi layout. And the property which is being discussed with this particular issue is certain number 174 and 175 of Capital. In this case, the claimant's actual partners of Shamba Industries was 4 people. One is Mr. D.K. Srinivas, one is Mr. Gauri Prasad, one is Madam Shanta, and one is Madam Gita. But they both, all the 4 had filed claim petitions before the LLC proceedings before the Special Land Acquisition Officer. And a Special Land Acquisition Officer's order telling that this particular area is being landmarked and is being acquired was challenged in an LLC proceedings before the Honorable City Civil Court in LLC number 83 of 2018 matters. LLC Land Acquisition case number 83 of 1987. When the proceedings started from 1987, section R30 of 158 when the actual partners were made as parties by the Special Land Acquisition Officer. This is the LLC land acquisition case report ownership. Wherein respondents 13, 14 the actual partners who represented they had filed their claim petitions. Subsequent to that, they were placed ex parte in these LLC proceedings. In 1996, one of the partners belonging to the Shamba Industries and the land which belonged to Shamba Industries Enterprises, she filed a petition before the Honorable High Court of Karnataka requesting for the challenging of the acquisition proceedings. Subsequent to that, in the year 1994, the petition came up before the Honorable High Court as there was an amendment carried out to section 38 of the BDA acquisition rules. When 38C was implemented, based on that, an order was passed by the Honorable High Court, which was produced to the Supreme Court. And in fact, in-page numbers, I can give you the notes. In-page number 184. It was measures Shanta Industries Enterprises represented by Srimati Leela, petitioner. But the order passed by the Honorable Court on first day of September 1992 was. I will take this Honorable Court to paragraph number 4 of the from 186 minutes, 486. It is lastly urged that the time of handing over possession, it had been noted that possession had been handed over subject to the condition that the land will be reconveyed based on the assurances given by the board. The petitioner made a representation as per Annexure G to the respondent for reconveyance. However, the respondent did not reconvey the land to the petitioner on the state of law as it stated then. Subsequently, by the Karnataka Act 17 of 1984, Section 38C has been introduced to reduce the rigor of the law. It is in the matters of reconveyance. It is made clear that power is granted to the authority concerned if the resolution has been passed to reconvey in favor of any person in either form if the land belongs to them or vested in or acquired by them for the purpose of development scheme as on the ground that it is not practicable to include such sites for the purpose of development scheme. Such sites by way of sale or lease in favor of such persons subject to the certain liabilities set forth herein. Paragraph number 5 is a direction given to the DDA.
Come to para 43 of the impugned order. Come to para 43 of the impugned order, page number 60.
Yes, sir. On the other hand, from the document submitted by the plaintiff, it is clear that such statement telecasted in the TV channel will definitely cause implication of the reputation of the parties. Therefore, the purpose of the opinion with the plaintiff. Here, what has happened is, my lord, this particular Shanta Industries actual partner, Leela, she did not approach DDA till 2011.
Admit appeal.
In this case, the operation of the impugned order may be said because it has impeded the rights of the defendant.
What is the irreparable loss that is going to cost to the appellant to tell me? What is the irreparable loss? Suppose in case if it is telecasted, then he'll be put to irreparable loss.
There is a, he has come very apprehensively.
Correct. Are you going to telecast us that?
Subject to the matter of the suit petition, my lord. Because I have got all valid documents before.
That will be subject to the outcome of the suit. That will be subject to the outcome of the suit. Or else you furnish a security saying that in case if he succeeds in the suit, then you are going to compensate him.
What has happened is, my lords,
please answer the question.
Which is being answered by the lower court. Actually, it has to be.
Suppose in case if a suit is decreed, what about the reputation of the respondent in the society?
Reputation subsequent to the program, he had actual course available is he has to either file a 499 IPC or when he can file a suit for damages, he actually has to ask for it accordingly.
No, so
or restraining defendants not to telecast the program legally. But the course open for them is, they should have, it is like an apprehension. It is like an apprehension where a party comes and says that there is a case filed against me. But in that case,
whether the appellant is telecasting?
Subject to the outcome of the suit petition.
So then why you want to stay now? Why you want an interim order? If you are not telecasting, then why you want an interim order? It requires consideration, I'm telling you. For that reason, I have admitted the appeal. It requires consideration.
Serial number 51, Vijeta R. Naik.
So the appellant in this case, please, Honours. Whereas plaintiff's appeal, please, Honours. Whereas it is an unfortunate situation, please, Honours, wherein the daughter has filed a case against the mother. Whereas the suit scheduled property belongs to, please, Honours, the plaintiff.
Just a minute, sir. Just a minute. Huh? Huh? So respondent is seeking time.
It is a matter which is required to be sent to the mediation because the litigation is between mother and daughter. The plaintiff is the daughter, please, and the defendant is the mother. Plus, the suit scheduled property belongs to the plaintiff. She derived title to the same under registered, say, gift deed executed by her father, please, she put up the construction. Both mother and the daughter were living together in the same house. Now she is being prevented from entering the house itself. It is being bolted from inside.
ಏನ್ರಿ ತಾಯಿಗೆ ಮನೆಗ್ ಬರ್ಕೊಡೋದಿಲ್ವ ನೀವು?
No, ಮಗಳಿಗೆ
ಮಗನಿಗೆ
ಮಗಳನ್ನ ಆಚೆ ಹಾಕಿ ಒಳಗಡೆ ಬಿಡ್ತಾ ಇಲ್ಲ. ಮೀಡಿಯೇಷನ್ ಕಳ್ಸಿದ್ರೆ ಏನಾದ್ರು ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಏನೋ ಅಂತ ನಾನು.
ಕಳ್ಸಂದ್ರೆ ಕಳಿಸ್ತೇನೆ, ನನ್ಗೆ ನೋ ಇಶ್ಯೂ.
Other side should also agree, please.
ಮೀಡಿಯೇಷನ್ ಕಳ್ಸೋಣ, ತಗೊಳ್ಳಿ. ಹಾಫ್ ಎನ್ ಅವರ್ 1:30 ಬಂದು ಹೇಳಿ.
I am for the respondent KV test matter.
The suit is decreed or dismissed?
Dismissed.
Suit is dismissed. Then RA also. In the RA, I filed one application for paying the operation of that.
Yes.
That was also dismissed. I will now
ಬರೋದಿಲ್ಲ. ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತಂದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಎಕ್ಸಿಕ್ಯೂಟಬಲ್ ಆರ್ಡರ್ ಅಂತಂದು.
It's the finding recorded by the appellate court measures.
ಎಲ್ಲ 2003 and 2006 all valid. The 31.5. 31.5 is not executable law 2003 and 6.
But I may be permitted to withdraw this petition and file it first. Later, because they.
No, 41 rule 5 ಬರೋದಿಲ್ಲ. At the most you can file an injunction application.
That's also dismissed, my lord. That application also filed, that's also dismissed. They have prepared an appeal. That has been suppressed.
ಏನ್ ಹೇಳ್ಬೇಕು, ನಿಮ್ದೆಲ್ಲ ಮುಗ್ದಿದೆ ಅಲ್ಲ, ಸುಮ್ನೆ ಅಪೀಲ್ ಒಂದು ಪೆಂಡಿಂಗ್ ಇಟ್ಟಿದ್ದೀರ ಅಷ್ಟೇ.
IN number 3 filed under order 39 root 1 and 2, a detailed order has been passed and that has been dismissed. Against that, MA has been filed before the district court. That is suppressed in the writ petition, my lord.
Mylar 1995, Karnataka 1812. Mylar 1995, Karnataka 1812. Murikere. ಅದು ಇಂಜಂಕ್ಷನ್ ಇದೆ, ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್. ಪ್ರಿನ್ಸಿಪಲ್ ಲೆಟ್ ಡೌನ್ ಸೇಮ್ ಇದೆ. ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ? ಅಲ್ಲ ಸರ್, ಲಿಬರ್ಟಿ ಏನ್ ಹೇಳಿ, ನೀವು ಹೇಳಿ. ಆಲ್ರೆಡಿ ಇಂಜಂಕ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಅದು ಹಾಕಿದ್ರೆ ಅದನ್ನು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ಸರ್ ಅದು ಕರೆಕ್ಟ್ ಅಂಬಿತೇಶ್ವರ, ಅದಕ್ಕೆ ನಾನು ಬರೋದಿಲ್ಲ. ನೀವ್ ಏನ್ ಬೇಕಾದ್ ಮಾಡ್ಕೊಳ್ಳಿ. ರೆವಿನ್ಯೂ ಅದನ್ನು ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಸಿವಿಲ್ ಸೂಟ್ ಅದನ್ನು ಬರೋದಿಲ್ಲ. ಟೂ 2006 KCCR 2006 3 KCCR 1757 ಅದು ಸೂಟ್ ಸಿವಿಲ್ ಸೂಟ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ರೆವಿನ್ಯೂ ಅಥಾರಿಟೀಸ್ ಅದನ್ನು ಬರೋದಿಲ್ಲ. ಇದಕ್ಕೇನು ರೆಮಿಡಿ ಇಲ್ಲ ನಿಮ್ಗೆ. ಅಪೀಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಫ್ ಅಪೀಲ್ ಒಂದೇ ನಿಮ್ಗೆ ರೆಮಿಡಿ. ಅದೇ ಆರ್ಎನ್ಎ ಡಿಸ್ಪೋಸಲ್ ತಗೊಳ್ಬೇಕು ನೀವೀಗ. ಅಲ್ಲ, ಅಬ್ಸರ್ವೇಷನ್ ಏನು ಅವ್ರು ಅಪ್ಲೇಟ್ ಕೊಡ್ದೆ ಸರ್. 2021 ಅಪೀಲ್ ಇದೆ, ಹೆಂಗಿದಾಗುತ್ತೆ ಹೇಳಿ. ಇದು
battle on this temple, law and order situation is created. All these things are just 3 days back. I have filed the application.
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ನೋಡಿದ್ದೇನೆ ನಾನು, ಟಿವಿದಲ್ಲಿ ತಗೊಂಡೆ. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ? ನೋಡಿದೀನಿ ನಾನು. ಬಟ್ ಕರೆಕ್ಟ್ ಈ ರಿಪಿಟಿಷನ್ ಅವು ಎಲ್ಲ ಡಿಸೈಡ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಅಲ್ಲಿ ಸ್ಟೇ ಪಿಟಿಷನ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಷ್ಟೇ. The appellants being agreed by the order on IN number 2 dated 20th November 2021, passed in RA number 31 of 2021 by the additional senior civil judge and JMFC Chenna Narayan Patna Hassan has filed this appeal. Brief facts leading rise to filing of this appeal are as under the appellants, the petitioners have filed a suit in OS number 66 of 2009 for suit is for
Declaration and injunction.
suit is for permanent injunction in the said declaration is
And injunction.
declaration and permanent injunction. In the said suit, the respondents appeared and filed a written statement. The trial court, after recording the evidence and after hearing the parties, dismissed the suit filed by the appellants. First of the appellant being agreed by the appellant agreed with the judgment and decree passed by the trial court, filed appeal in RA number 31 of 2021. In the said appeal, the petitioners have filed an application seeking for a stay of judgment and decree passed by the trial court. First of the trial court, passed by the trial court. First of the appellate court, the said application was opposed by the respondent by filing the objections. First of the appellate court, after hearing the parties, rejected the application, hence this petition. Heard the learned counsel for the petitioner and also learned counsel for the respondent.
Notice ಆಗಿಲ್ಲ ಕೇವೇಟರ್ I'm for the ಕೇವೇಟರ್ ಮೇಡಮ್. It's a preliminary hearing.
Heard the learned counsel for the ಕೇವೇಟರ್. Learned counsel for the petitioner submits that the trial appellate court has committed an error in the passing the impugned order. He further submits that if the judgment and decree passed by the trial court is not stayed, there will be a law and there will be law and order problem. He further submits that the contents law and order problem on the
additional document I have filed
stay here. Heard the learned counsel for the petitioner submit that the trial court has committed an error in rejecting the application filed by the petitioner. He submitted that the impugned order passed by the trial court is arbitrary. Hence, on this ground, he prays to allow the writ petition. Per contra, learned counsel for the respondent supports the impugned order. Heard and perused the reports and considered the submission of the learned counsel to the parties. It is not in dispute that the petitioners have filed a suit for declaration and injunction in OS number 66 of 2009. The trial court dismissed the suit void judgment and decree dated 6/4/2020. First of the appellant and the petitioners being agreed by the order, judgment and decree passed by the trial court, referred appeal in RA number 31 of 2021. And in the said appeal, the petitioners have filed an application under order 41. First of the judgment and decree passed by the trial court is not an executable order. When the judgment and decree passed by the trial court is not an executable order, question of staying the operation of judgment and decree passed by the trial court in OS number 66 of 2009 does not arise. First of the said view has been reiterated by the coordinate bench of this court in case of Gangama versus Veeranna, reported in ILR 1995 Karnataka 1812. The in view of the same, the trial court, the appellate court was justified in rejecting the application filed by the appellant. Appellants, I do not find any grounds to interfere with the impugned order. Accordingly, the petition is dismissed. Dismiss and sir. Dispose of any ಸರ್ ಡಿಸ್ಪೋಸಲ್ ಹಂಗ್ ಇದು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಎದ್ರಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ನೀವು ಹೇಳಕ್ಕಿಂತ ಮುಂಚೆ ನಾವೇ ಮಾಡ್ತೇವಲ್ಲ.
Shri Vijay Kumar.
Year 1989, yes, one case, all of brothers. Boys number 577 of 1989. Then the subject of this is the
Or the learned counsel to the petitioner, issue notice to respondent. In addition to petitioner is permitted to serve a copy of the petition along with the next and the counsel appearing for respondent before the trial court. The petitioner and the respondent filed a suit for permanent injunction in verse number 267 of 2018. In the said suit, the respondent has filed an application seeking an order of temporary injunction. So the trial court rejected the said application with order dated 18th December 2018. So the respondent agreed with the order on IA number 1. After the trial court referred appeal in MA number 6 of 2019. So the appellate court allowed the appeal with order dated 12/11/2021. Whether the respondent had a benefit of interim order before the trial court or interim order it can learned counsel for the petitioner submit that the respondent had no benefit of ex parte order of temporary injunction. His submission is placed on record. In view of the same, both the parties are directed to maintain status quo in regard to the possession of the suit property till next date of hearing.
54, Shri G.S. Balgangadhara.
Status quo ಮಾಡಿದ್ದೇನ್ರಿ status quo. Yes, sir.
May not be decree granted is only for demolition and for declaration. 3 months time was granted. But when not enlarging the scope of the executive court works, it's also for possession. It's quite wrong. The operative portion of the judgment may not be able to determine. This is the decree grant. But the plaintiff suit is decreed. It is declared that plaintiff is owner of the property, whether it is specified and also control, which includes building construction.
Last 5 lines freedom to put up the construction and
Yes, the defendants are directed to demolish construction made by them within the said portion within 3 months from the date of defendants, their agents, servants, or anybody claiming under them are hereby restrained by way of operative petition from unauthorized attempting to put up construction of the house property, thereby interfering with the plaintiff's position. Both the parties are directed. No relief of position is granted. That is my humble submission. No,
for the learned counsel to the petitioner. Issue notice to respondent. In addition to it, petitioner is permitted to serve a copy of the petition along with the annexures and the counsel appearing for respondent before the trial court. The petitioner and the respondent filed a suit in respondent 1 and 2, no? 1 and 2 filed a suit in verse number 125/2001 seeking for a relief of mandatory injunction, declaration, permanent injunction, and mandatory injunction. The trial court word its judgment and decree dated 15/2/2007 partly decreed the suit of the respondent number 1 and 2 and declared that the respondent number 1 and 2 are the owners of the property measuring east-west 77 feet, north-south 112 feet, which includes the building constructed by them shown in the plain statement, and further directed the petitioner to demolish the construction made by them within the said portion within a 3 months from the date of decree. And further, the petitioners were restrained by way of permanent injunction from unauthorizedly attempting to put up a construction of house in the suit scheduled property, thereby interfering with the respondent's peaceful possession and enjoyment of the suit scheduled property. First up, the respondent filed an execution petition in EP number 1 of 2018, wherein in the execution petition, the respondents sought for a relief of declaration, sought for demolishing the construction undertaken by the petitioner as shown in the petition sketch scheduled property, and also sought for delivery of possession of the suit scheduled property to the decree holder. From the perusal of the judgment and decree passed by the trial court has not granted a relief of delivery of possession of the suit scheduled property to the decree holder. First of the trial and the executing court has it is the contention of the learned counsel for the petitioner that the execution petition filed with the respondent is not maintainable as it is barred by limitation. First of, we further submit that the trial court, without considering the said aspect, has proceeded to pass an impugned order. Hence, his submission is placed on record. There shall be interim stay of further proceedings in execution petition number 1 of 2018, pending on the file of Civil Judge Junior Division, Kotragera, Tumkur.
ಟೈಮ್ ಎಲ್ಲ ಆಗಿದೆ.
Petitioner by me, my lords, serial number 52.
63.
My lords, I represent the petitioner. The matter has been settled before the mediation center, my lords. The parties have amicably settled the matters, my lords.
And the submissions made by the party, the matter was referred to mediation center Chikmagaluru. So the parties have appeared before the mediation center and filed a memorandum of settlement under section 89 of CPC before the mediator. Mediator has accepted the said memorandum of settlement and sent a letter to this court, white letter dated 8/2/2022, along with the memorandum of settlement. In view of the same, nothing survives for consideration in this petition. Appeal accordingly, appeal is disposed of.
Great.
Case called twice, none appears for the petitioner. Let the petition be registered in the second week of March.
Number 32.
32, my lord. I am for the petitioner in this matter, my lord.
ರೇವಣ್ಣ ಬಳ್ಳಾರಿ ಇರ್ಲಿಲ್ಲ ಬೆಳಗ್ಗೆ.
ರೇವಣ್ಣ ಬಳ್ಳಾರಿ.
Case called twice, none appeared for the curator. Let the petition be listed on Tuesday.
February.
Case called twice, none appeared for the parties. Let the petition be listed in the second week of March.
Number 51.
My lord, serial number 59, my lord. I am appearing for the respondent number 3, my lord. Sorry. I'm sorry, my lord.
Ravi B. Nayak ಅವ್ರದ್ದು sir. ಇವ್ರು pass out.
Learned counsel for the parties jointly submit that there is a possibility of settlement when not may be referred to mediation. Submission is placed on record.
Nora sir, JP Nagar. Mediation center at Siddhaya Road.
That is referred to
Bangalore
mediation center.
mediation.
Parties are directed to appear before mediation center on 28th. On 7th March at 11 p.m. Registry is directed to forward the copy of this forward the copy of this order to the mediation center. Let the appeal be listed after the receipt of report from the mediation center.
Pleading matter, serial number 56. CM Nagapatana.
My lord, I am appearing for the respondent. My colleague is before the court, my lord. I am appearing for the respondent.
He's the respondent.
My lord, I am appearing for the respondent.
Yes, sir, I heard you. But you are appearing for respondent.
Yes, the petitioner, my lord.
There
is a direction by this honorable court to secure the records from the trial court. Because of that order, my lord, the proceeding before the trial court is not going on. My learned friend has to argue the matter. My learned friend has challenged the order passed.
Pardon? The madam matter is of the year 2016. At the request of learned counsel for the petition, let the petition be listed in the second week of March.
Date may kindly fix, my lord.
Second week of March, sir.
With request of my lord.
Amaresh, we are ready for respondent.
That's right.
CM Shivam Prakash.
No further, the proof was filed on 21/12/2013, and within a period of 1 and a half months, they have entered into this no further compromise. One of the question is now before my lord. The crux of the matter is the property which is to be paid and paid us, which my mother has acquired.
is herself a performer. And during her lifetime, she entered into an agreement with third party to sell his property at 3 lakhs. For a consideration of rupees 25 lakh. Out of 25 lakh, the Rangama and Havasar, that is the daughters and the son, they had a 15 lakh out of this transaction. Now, in the meanwhile, one of my brother has filed a suit with this suit for declaration. Declaration that one of the bill executed the late Rangama, as if this property has been bequeathed to this first respondent. And these parties, the prosecution and other sections are not educated. And the court. And in that, this local subject matter of this agreement. He is home and home bequeathed for the first respondent. That is the text of this local document. So afterwards, when they have received about 15 lakhs, and the party when he is insisted, then when we look into all these things, my brother himself has made statement fraud. Now I am before my lord sitting that whatever the compromise he has entered by approach to fraud, it is a fraud he has made on the court and also on me also, because there are uneducated. That has to be settled. It's not a fair and it's not a legal compromise.
Petitioner is being represented by counsel. Come to page number 50. 50. And she has signed on a compromise petition. Come to page number 49. Her signature is there.
Is represented and now taking advantage of electricity because we are obligated and we have daughters and children and Rangama. We have received when my mother was alive 10 lakhs and 25 lakhs was a sale consideration. And when the gentleman has demanded for the execution of this sale, meanwhile my brother who is an illegally has
Sir, you have signed the compromise petition after reading the contents of the compromise petition.
Reading the contents, that's what in the grounds are made up and said that there are uneducated. My brother himself has made a problem. This is one aspect of that. Now, so as this pleading after this settlement and compliance and the law. The suit that my brother was filed on 2018, just before this suit. Immediately I am getting it served and he entered on the first page saying this document from Bhopal. This is on 32/2014. I paid a hardly not even 1 month or 2 months. This is one aspect. Our court has taken.
Have you raised this ground in your writ petition? Please.
The issue under the constituency is perpetrated by fraud and initiated the respondent by mischief and by misunderstanding and misstep the local time. If the sale is not such a correspondent will the agreement already executed and substantial certainly received. As per the police issue, who has seen the case of the day in order to give the right to put under the sale to get exposed. The transaction is until and not such a law cost for the way. Therefore, in order to knock off the property of the cost as a create a corporate decree before local. Thus, that the respondent has paid issue to not cost for user. These are the three grounds are raised.
ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇರೋದು ನೋಡಿ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ನೋ ಗ್ರೌಂಡ್
Lack of this property made all these arrangements. Where such a single circle where there is such a broad place that the parties so there is such a local that all can
I pleaded about the fraud. What type of the nature of fraud? ಏನದೆಲ್ಲ What is what is CPC? Correct. Pleading ಇರ್ಬೇಕು ಇಲ್ವಾ? ನಿಮ್ದು ಏನಿದೆ ಪ್ಲೀಡಿಂಗ್? ಏನಿದೆ ಹೆಂಗೆ ಫ್ರಾಡ್ ಪ್ಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಏನೇನಂತಂದು? ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಪ್ಲೇಂಟ್ ರಿಟ್ ಪಿಟಿಷನ್. ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ರಿಟ್ ಪಿಟಿಷನ್. Not necessary. If it is not necessary, then I'll dispose it.
I'm saying I'm doing that.
At the request of learned counsel for the petitioner. When do you want?
The next week, because
Let the petition be listed in the second week of March.
You want to get it, go to find it, I will.
First of all, ರಿಟ್ ಪಿಟಿಷನ್ ಎಲ್ಲ ಪ್ಲೀಡ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ ಪ್ರಕಾರ ನೋಡಿದ್ರೆ ಏನೂ ಇಲ್ಲ ಫ್ರಾಡ್ ಅಲ್ಲಿ. Just a stray sentence. He has played a fraud on the stay. That will not be sufficient for setting aside a compromise decree. Yes.
With the Lord's permission.
Yes.
My lord, I'm appearing for the respondent number 3 in this matter, my lord, serial number 59.
Yes, madam. Pardon? What do you want?
Completed documents are 3. Petition amendment of pleading.
Petitioner with the order on IN 7 dated 26th July 2019. The additional civil judge and JMX Nagri have legal rights to file the dispute petition as under the petitioner filed suit seeking for relief of declaration and permanent injunction against the respondent number 1 and 2. Yes, sir. She has said that already matter was heard. For that reason, otherwise I could. You want adjournment? Just declare the counsel to the petitioner. The request of permit counsel to the petitioner, let the petition be listed.
ಮುಟ್ಟಿದ್ರೆ ಬಟ್ ಅದುಗಳು ಹೊರಟು ಹೋಗುತ್ತೆ.
Second week.
ಮಾಡಿದ್ದೆ.
Number 16.
I appear for the petitioner, my lordship, in this case. Both 60 and 61, my lord. In the first petition, my lord, 60, I have filed an application for amendment of client under Art 6-17. And when the matter was going on in the trial, my lord, during the final stage, when the COVID operation was there, my lord, for the period of 2 years, the respondent, my lord, as per contesting respondent number 4, he has entered into the property and he has put up a shed and all those things, my lord. I have filed a complaint and immediately I filed an application before the trial court under Art 6-17, seeking an amendment of prayer for recovery of possession, my lord. After contest, my lord, I have also filed the written arguments along with the complaint copy. The trial judge, my lord, has come to the conclusion that I have not disclosed the date of entering of the respondent into the property. As such, he has on the only ground that he has dismissed my application. But in fact, it was not correct, my lord. I have filed the objections and also the affidavits therein to that. When the respondent came into the property, and this is a suit for declaration and injunction I have filed before the trial court, my lord. Now it is posted for judgment, my lord. Recovery of possession, my lord. If I succeed, I can come out of the relief, my lord.
Yes.
I have also stated in the evidence also, my lord, that recently the respondent has come to the property and has knocked out the plaintiff out of the associated property, my
Date
lord.
of disposition. Date of disposition.
Disposition at the time of the
stated in
recording of
your
the
application.
Sorry, my lord.
Stated in your application.
Yes, my lord.
Show me.
My lordship may come to the application, my lord, which I have filed.
Page number 91.
Yes, my lord. 1 second, please. 91, my lord. Affidavit, my lord. Affidavit. I have stated in para number 11, my lord. I submit that after closing my cross evidence and when matter posted for defendant number 4 evidence, the defendant number 4 on 5/8/2021, who came near the suit property along with some Kunda and land mafia elements, started plowing the suit land with tractor and also putting up illegal fencing and took photographs of his picture and other agriculture works to enable him to produce it to the court to proclaim that he is in possession of suit land. Though from the beginning of filing of the suit, I am lodging police complaints, but the defendant number 4 in one or other way tried to take forcible possession, which he has succeeded now.
When the evidence of PW2 and 3 was completed,
it was on the way, my lord. It was on the way.
Please come to para number 9 of the impugned order.
Please, my lord. I have gone through the evidence of the witness examined by the plaintiff. The plaintiff has examined 2 witnesses as PW2 and 3, and the evidence of in chief of PW2 and 3 were filed on 17/9/2021, and they were cross-examined on 24/8/2021. I'm going through the evidence of PW2 and 3. Not even a whisper is made with regard to. In fact, my lord, the evidence clearly discloses in that last para, my lord, in the cross-examination, I have clearly stated that they have forcibly entered into the property. In the evidence, I have clearly stated both PW2 and 3. That has not been observed by.
PW2 and 3.
Yes, my lord. The evidence I have not, evidence copy I have not produced before the court, my lord.
Learned counsel for the petitioner seeks time to produce the copy of deposition of PW2
Now,
and 3.
the matter is posted for judgment, my lord.
Let the petition be listed in the first week of March.
The next matter, my lord. The next matter, my lord. I appear for the petitioner, my lord.
Yes.
I filed this is a suit for
Application
mandatory.
for appointment of court commissioner.
26 rule 9, my lord. This is a suit for mandatory injunction and the recovery of possession, my lord.
This is first week.
My
First
lord,
week.
Number 62, GN Pavan.
ಇಲ್ಲೆಲ್ಲ ಮುಟ್ಟಬೇಡಿ, ಮುಟ್ಟಿದ್ರೆ ಹೊಟ್ಟೋಗುತ್ತೆ.
Petitioner in this matter, my lord.
ಕೆಳಗಡೆ.
GN Pavan.
Appearing for the petitioner counsel in this matter, my lord. Your lordship, what is thought to be challenged is annexure A, my lord.
ಬಿಸಿ ಮಾಡಿ
I think there's some disturbance, man.
Rule 70.
Page annexure, page 28, man.
Copy was served on the council appearing for it. Let them file an objection and trial court shall decide. The petitioner being agreed, petitioner agreed by the order dated 28/1/2022, passed in invoice number 1747 of 2021 by the Principal Senior Civil Judge, Bangalore Rural, has filed this writ petition. Brief facts leading us to filing of this writ petition are as under. The respondents filed a suit invoice number 1747 of 2021 for relief of mandatory injunction, mandamus, suit for partition and separate possession. In the said suit, the respondents filed an application. Seeking for amendment of claim. First of the trial court filed an application for amendment of claim. First of the copy of the said application was not served on the council appearing for petitioner before the trial court. The trial court has proceeded to pass an impugned order. Hence, this writ petition heard the learned senior counsel's registration for Pavan GN appearing on behalf of the petitioner, and also Sri Prasad Shantan Gowda for respondent number 1 to 3. Respondents. Learned senior counsel submitted. The respondents have filed an application seeking for amendment of claim. Copy of the said application was not served on the counsel appearing for the petitioner before the trial court. The trial court, without providing an opportunity to the petitioner to file an objection, has proceeded to pass an impugned order. He further submit that the impugned order passed by the trial court is in violation of principles of natural justice. Hence, on this ground, he prays to allow the writ petition. The counsel appearing for the respondent, Sri Prasad Shantan Gowda, fairly concedes that the respondents have not served. The learned counsel appearing for the respondent has not served a copy of application filed by the petitioner before the trial court has not served a copy of application on the counsel appearing for petitioner before the trial court. Hence, on this ground, he prays to dispose of the writ petition, heard and peruse the reports, and consider the submissions of the learned counsel appearing for the party. It is not in dispute that the respondents have filed a suit for partition and separate possession. In the said suit, the respondents have filed an application seeking for amendment of claim.
Actually, amendment of cost title, my lord, it's not even amendment of claim. In the order 6, rule 17, they seek to amend the cost title. Anyway, I'll file my objection and I'll argue that later, my lord.
Does it not amount to pleading?
No, cost order 1, rule 10, there I have to file, my lord.
No.
This is implementing application.
Application is under which provision?
Order 6, rule 17, amendment of
What order 6, rule 17 says?
My lord, amendment of pleadings, my lord. If they want to implead somebody, they have to file order 1 rule 10, my lord.
But now application is filed under order 6 rule 17.
Please,
Correct. If you file an objection.
I'll file my objection and argue. Anyway, that is not the subject matter, my lord. I'll file my objections. That may not be.
Where is the impugned order? Page number?
25, my lord.
27. Okay, in the respondents have filed a suit for partition in separate position. In the said suit, the petitioners have filed an application seeking for amendment. On 21/1/2022, the respondents have filed an application praying for advancement of the case from 7/2/2022 to 20th/1/2022. The trial court taken the application and the trial court has advanced the suit on 20th/1/2022 and taken up the matter on board, and thereafter the petitioner, the respondents filed an application for amendment of pleading. First of the trial court without providing an opportunity, admittedly, the counsel appearing for the respondent has not served a copy of application for amendment of pleading on the counsel appearing for the petitioner, and further the trial court without providing an opportunity to the petitioner to file an objection to the said application has allowed the application by order dated 20th/1/2022. First of the trial court has committed an error in allowing the application filed by the petitioner without providing an opportunity to the petitioner to file objection. First of thus, the impugned order passed by the trial court is in violation of principles of natural justice. Hence, on these grounds alone, the impugned order is liable to be set aside. In view of the above discussion, I proceed to pass the following order. The repetition is allowed. Impugned order dated 20th/1/2022 is set aside. Respond, the trial court is directed to reconsider the application filed with the respondent after providing an opportunity to the petitioner to file an objection and thereafter pass appropriate order in accordance with law.
I'm grateful to my lord.
Veeranaji Tigadi.
You are appearing for? Pardon? Then a counsel for the petitioner seeks and let the petition be listed in.
With my lord's permission, serial number 55, and my matter is called, my lord. The link was disconnected, my lord. I pray it may be taken off a Tuesday or Wednesday, my lord.
Serial number
55.
55 second week of March.
Tuesday or Wednesday, my lord.
Stenographer ಗೆ ತಗೊಂಡು ತೆಗೆದಾರೆ ಫೈಲ್.
Tuesday, my lord.
Yeah, Tuesday.
I am grateful to my lord.